Welcome everyone to this event today to present and discuss the study on determinants of anti-trafficking efforts, which has been conducted by the British Institute of International and Comparative Law and funded with the generous support of the Office to Monitor and Combat Trafficking in Persons of the United States Department of State. By way of very brief introduction to the study being discussed, its findings are the fruits of 2.5 years of work undertaken to understand the factors that shape and determine governments' anti-trafficking efforts and that influence compliance with and implementation of international standards on counter-trafficking. Its methodology was robust and involved a review of available literature as well as a quantitative analysis of existing data sets. It also involved more than 50 interviews with international and regional stakeholders, some 200 survey responses, and 14 domestic case studies. My name is Marika McAdam. I'm an independent international law and policy advisor, and I have the very great privilege of being involved in this work as an expert panel member, and I helped in its design and review. And I'm delighted to have been involved in this important work, which I consider to be both ambitious in scope and pioneering in purpose. I think that so far the weight of counter-trafficking research has focused largely on what is done. Rarely is there any inquiry as to why states do what they do or indeed fail to take action. And it's my hope that these findings that we're going to learn about today will equip the counter-trafficking community to better prioritize and allocate effort and to not only shape response, but perhaps even to catalyze it. So I thank the British Institute for the opportunity to support this study and for the honor you have given me today of chairing this event. With me, I have an esteemed group of speakers, including Dr. Jean-Pierre Gauci and Dr. Noemi Magugliani, who led the work that we're presenting today. I'm also honored to be sharing the screen with Martina Vandenberg, founder and president of the Human Trafficking Legal Center. And of course, we're thrilled to be joined by the UN Special Rapporteur on Trafficking in Persons, Professor Siobhan Mullally. I look forward to introducing each of these colleagues in more detail as we move through today's agenda. Our proceedings today will begin with a presentation of the research findings, and then we'll turn to discussants to share their views on the utility and the implications of these findings and any other reflections they may have. We will then turn to you, our audience, for around 25 minutes of questions and comments. And for that purpose, I invite you to please use the chat function to put forward your questions and comments throughout our discussions. Now, I've been requested to keep us to time, so let me apologize to my colleagues in advance for any abruptness on my part in service of that goal. And on that note, I think it's an appropriate time to now move us forward to our first session of the agenda. So to present the research findings, allow me to introduce Drs. Jean-Pierre Gauci and Noemi Magugliani. Dr. Gauci is the Arthur Watts Senior Research Fellow in Public International Law and Director of Teaching and Training at the British Institute of International and Comparative Law. He holds a PhD in law from King's College in London and a Doctor of Laws and Magister Juris in International Law from the University of Malta. Beyond his work at the British Institute, Dr. Gauci is also a co-founder and co-director of the People for Change Foundation, being a human rights think tank based in Malta. He lectures in international migration law and ocean governance at the University of Malta and lobbies in fields of migration, asylum law, anti-discrimination, and of course, anti-trafficking. His primary research areas include international migration and refugee law, and he consults to international governmental and non-governmental organizations. Dr. Magugliani, who joins him, is a research fellow in anti-trafficking law and Policy at the British Institute. They hold a PhD in law from the National University of Ireland in Galway, where they conducted research focusing on trafficked adult men, gendered constructions of vulnerability, and access to protection. Dr. Magugliani also holds an LLM in International Human Rights Law and Policy from University College Cork and a BA in International Relations from the Uni of Milan. They're also an advisor to the UN Special Rapporteur, who's joined us today. Dr. Magugliani has also collaborated with the Secretariat of the Council of Europe's Greta and IOM, and have research and teaching experience in migration, asylum law, and human trafficking, as well as human rights. Long introductions to extraordinary people. Jean-Pierre and Noemi, I give you 45 minutes.
Thank you very much, Marika. We're going to tag team the presentation, so we'll go through different slides as we go. So just to get started, Marika, you've already outlined the methods of the research project, so I won't go into those, and I'll skip right ahead to some of the findings. So I'll start with general comments that we have about what determinants are and how they're connected, and then we'll talk through some of the specific determinants that we've looked into over the course of our research project. But when we were kind of looking through all of the determinants, a few kind of general comments arose about how the different determinants come together, but also how they can be categorized. And I think the first one is just how interconnected these determinants are. And the diagram that you see kind of in the corner on the slide was an attempt for us to actually visualize some of the findings from the research and those interconnections, which resulted in a bunch of lines that don't really make sense and don't really help anyone. But basically what came across very clearly is that all of these determinants are linked to one another, and you cannot really understand one without understanding the others, but also you cannot really expect one particular determinant to work on its own unless you also consider all the other determinants that are in play. The other thing that we found was that all of these determinants are not linear. It's not that if you have one determinant or a handful of determinants, they will always move things in the right direction or in the same direction. Moreover, determinants can be determinants in and of themselves. They can be determinants of anti-trafficking outcomes. They can themselves be outcomes of other determinants, which then also determine other outcomes. And they can also be determinants of other determinants. So you have kind of some of our determinants which are outcomes in themselves, but are also determinants of other determinants and of other outcomes. Some of the determinants are positive. Most of the determinants we have looked at are positive determinants, but some are also negative determinants, pushing things back or holding governments back from improving anti-trafficking efforts. Things like corruption, for example, comes across very clearly as a negative determinant. Some are active determinants involving people, institutions, organizations pushing for specific things, while some are passive. They provide the context within which anti-trafficking efforts can be improved, but they're not pushing directly themselves. Some determinants are specific to anti-trafficking, whether that's a particular instrument, for example, that is trafficking specific, or a particular monitoring process that is trafficking specific. While some are contextual. They determine the broader context in which anti-trafficking efforts develop, whilst others are tangential. They determine efforts in related areas such as, for example, children's rights, labor rights, etc., which by developing those improvements can also help or indirectly affect anti-trafficking efforts. Again, both positively and negatively. Some determinants have a direct effect on anti-trafficking efforts, whilst others have an indirect effect. And obviously, some determinants will have both a direct and an indirect effect. So, for example, monitoring processes that I've already mentioned have a direct effect when states engage with them directly, but they also have an indirect effect when civil society organizations are able to use the comments, recommendations, etc., that come from monitoring processes in order to advocate at the domestic level themselves. Some are context specific. All determinants are context specific. You need to understand the particular determinant as it is applied and as it is practiced within that particular domestic context. So for example, the role of civil society organizations comes across very clearly as being particularly important, as we will see. But obviously the particular context in which those civil society organizations are engaging, the space which civil society enjoys in those countries, etc., will have a massive impact on how strong or weak a determinant civil society engagement is. Some determinants are personal, some are institutional, some are social and cultural. Obviously, we look at, for example, individual political will, which is very kind of personal determinant, but we also look at kind of the broader social and cultural context within which anti-trafficking efforts are developed and implemented. Determinants will also impact kind of different parts of the response or different stages in responding to trafficking, from acknowledging trafficking as an issue, framing how we understand trafficking in that particular context, whether it is prioritized or not as a policy issue, the development of law, policy, and practice, whether resources are allocated or not, the implementation, as well as monitoring and evaluation of anti-trafficking efforts. The type and stage of response will also be affected differently by different determinants. So for example, if we only acknowledge international trafficking, the type of response is likely to be different. Obviously, we also have different modes of responses, and states will react to different types of determinants in different ways. And some kind of responses are more formalistic, the adoption of a policy so that a monitoring body sees that we have now adopted an action plan on trafficking, whilst others are more substantive, practice-focused developments, which actually impact kind of in the longer term. Obviously, some determinants are structural. They provide, again, that context, that framework within which anti-trafficking efforts are being developed, whilst others are pressure points pushing for a particular change at a particular time. So I think those are the general comments, and I'll now move on to starting to look at specific ones. And the first one is political will, which is possibly the widest of determinants that we have. And it is a determinant that if you ask 20 people, you will probably get 25 different understandings of what we mean by political will. So one of the first things we did in the project is, together with colleagues as well as with the expert panel, etc., we identified our own working definition of political will. It's not a working definition that everyone will use, but it is the working definition that we went with, which is that of the sustained commitment of key state decision makers to combat human trafficking and to materially improve their anti-trafficking measures, in particular through the development, implementation, resourcing, enforcement, and monitoring of legislative, policy, and practical processes. Now, political will as a determinant is clearly one of those where it is clearly a determinant in and of itself. You probably won't have much anti-trafficking efforts without some sort of political will, but it is also the sum outcome of other determinants. It comes out of other determinants as well. And we have a quote on the right from one of our interview participants, which clearly kind of summarizes this. Those other determinants can be things like the international reputation of the particular state, etc. Now, when we talk about political will, we often see political will in anti-trafficking in contrast with or in comparison with political will for other political priorities in the country. The political priorities, there are many political priorities, but very often we see trafficking being kind of in competition with other priorities, but also heavily impacted by what those other priorities might be. And immigration control is one of the key examples where we see where immigration control or restrictive immigration policies have very strong political support or there's a lot of strong political will for restrictive immigration policies. Anti-trafficking efforts tend to suffer. We also see political will for anti-trafficking specifically or within kind of a broader context, such as reputational reasons for the country or economic reasons for the country. For example, you can, in the context of Thailand, which was one of our case studies, we saw that the kind of economic repercussions of things like trade barriers from the EU in the context of the fishing industry were a huge push for states to improve their anti-trafficking efforts in that particular context. Whilst in other cases, we see political will which is specific to anti-trafficking, where the particular individual, the particular institution, the government more generally, the state more generally, are actually committed to improving anti-trafficking for the sake of improving anti-trafficking. Political will can also be individual and collective, and we've looked at different countries where political will was exhibited at both of those levels. In some cases, so the UK, Bahrain, for example, and Chile all came out as countries where individual political will was particularly important. I think something to keep in mind here is that the placement and the position of power of the individual will have a strong influence on how that political will translates into change at the kind of policy level more broadly. However, collective political will is then kind of the broader political will of kind of a particular government, a particular kind of institution within the government, and bringing kind of the rest of government with you on those. The other thing that I want to mention with individual versus collective political will is that individual political will, very often when we think about it, we think about politicians, but it's not only politicians. It can be policymakers, it can be civil servants, it can be people working within institutions that are in a position where they can really push certain agendas. That can be in the context of donors, it can be in the context of home offices, it can be in the context of different ministries, it can be particular lawyers taking certain cases, it can be particular judges making certain decisions, etc. Political will can be formalistic or substantive, and this links back to the issue of other priorities and what the real reason for that political will is. Formalistic political will is kind of more looking like we have the political will to do something, while substantive is actually showing that that political will is there and pushing forward certain positive agendas in our case. The other side of it is that we see in almost all of the countries where there wasn't political will, where there was a lack of political will, that was a hindrance to anti-trafficking policies. But what's important to keep in mind is that it's not only a complete lack of political will, but it might also be a limited political will. So you might have political will to address one type of trafficking or one type of victim of trafficking, which then is potentially a benefit, a good determinant for some measures, but a negative determinant for others if those other types of trafficking, those other types of victims, etc., are being sidelined or excluded from the efforts that are being undertaken. Political will can be top-down, so starting from someone in a position of power, kind of bringing others with him, or bottom-up, coming through civil society, coming through the electorate, etc., etc. Okay, moving on, because I'm worried about time. Can we move to the next slide? Yeah, I think that's over to you.
Indeed, and a lot of what Jean-Pierre mentioned already in the context of political will, we've also found in acknowledgement and framing, which has emerged as one of the main determinants across the literature review as well as the case studies. And acknowledgement and framing of trafficking determine whether and the extent to which combating trafficking is prioritized, which kinds of responses are engaged, how the responses are designed, and how they are implemented. The framing of trafficking is not neutral, and it is itself determined by a series of other factors, including, for example, international law, political will, civil society organizations, data and research, the media. Now, the lens through which human trafficking is framed is also to be understood as highly context dependent and embedded in a country's history, cultural, and social norms. And we have first focused on the government's acknowledgement and framing of trafficking. Some governments might be unwilling to acknowledge that trafficking is a reality within their territories for a wide range of reasons, including lack of political will, international reputation, and or unavailability of resources. The government may be unwilling to acknowledge that trafficking exists, yet it can be pushed to do so through other factors, most notably international pressure, including in the form of the TIP report, civil society organizations, pressure, case law, and media exposure of trafficking cases. But acknowledgement is not binary. There are nuances within acknowledgement that must be considered in detail. Indeed, certain governments might acknowledge, as Jean-Pierre already mentioned, only specific types of trafficking or certain trafficking experiences while denying others. And this might tie in with economic considerations, considerations of religion and morality, as well as issues of corruption. But once trafficking is acknowledged as an issue, whether partially or in its totality, governments still retain a level of discretion with respect to the way in which they frame the phenomenon. So in this context, law is one of the most powerful framing tools for governments. An inclusive definition of trafficking tends to be more result in comprehensive those types of trafficking is not only framed in law, but also in public policy and public discourse. And because of its nature, it can be framed as a migration issue, a labor issue, a criminal issue, or a human rights issue. And when trafficking is framed narrowly, as for example, transnational only or through a criminal lens alone, attention tends to be placed on the individual trafficker rather than on structural vulnerability factors, resulting in partial anti-trafficking efforts, if not detrimental. Now, in addition to the role of the government, the media also plays a significant role in the acknowledgement and framing of trafficking. Where media enjoys freedoms, their role is particularly important. So media can expose trafficking incidents and shape public opinion, which in turn can affect the political climate and policy priorities even. Exposure, however, once again, is not neutral, and it is also subject to framing processes. Scholars have highlighted, for example, how media outlets tend to focus on certain types of trafficking, in particular trafficking for the purpose of sexual exploitation, often in an over-sensationalized manner, which often again involves a gendered narrative, to which we will return. And lastly, framing is impacted by the availability and quality of data, which might influence and be influenced by the understanding of trafficking and its nature. But data and research are not only relevant to framing, but also more broadly to anti-trafficking efforts. New data can facilitate change, while the lack of reliable data can obstruct the effectiveness of policy responses. So availability and reliability are key words here. And although data is often presented as objective, data collection often suffers from collection biases and definitional challenges. Now, generally, data is collected by governments or by external organizations. And when governments collect data, they make a political decision on whether or not to collect it, and if they decide to collect data, on which data to collect and how to collect it. So in Chile, for example, interviewees have argued that there is a selection bias with data collection distorting understanding of trafficking because heavily focused on trafficking for the purpose of sexual exploitation. In other instances, for example, Armenia, that's collected but not disaggregated, thus giving only a limited picture of the nature of trafficking in the country. But even when data is collected, disaggregated, shared, must meet. So for example, low prosecution numbers may reflect poor efforts, poor infrastructure, but also may be taken by governments as evidence that there are few trafficking cases in the country. But what changes if data is collected externally? So in these instances, first and foremost, governments still have a degree of discretion in acknowledging, accepting, and responding to data and research that's collected and produced by third parties. So data be posted, delegitimized, or ignored by governments, either on the basis of justified concerns, for example, partiality, or lack of transparency as far as methodology is concerned, but also they can be distrusted or delegitimized as a means of political strategy. Rejection, denial, and deflection can, however, be mitigated through other determinants, including, for example, external monitoring, civil society organizations, as data collected externally tends to be more publicly available than that collected by governments. And it can be used to pressure governments into acknowledging the problem and improving efforts. And this last element is crucial because data and research are insufficient to trigger change alone, but they're inserted in an ecosystem of tools that are available to anti-trafficking stakeholders. Now, relevant to acknowledgement and framing are also reflections on culture, victimhood, and discrimination. The social and cultural context-based framing and understanding might lead governments to include or to exclude specific categories of trafficked persons in anti-trafficking efforts. Now, some states struggle to understand victimhood beyond stereotyped images, which might be reinforced by bias action, which is too hard to break cycle reinforcing biases. Now, culture and victimhood are heavily impacted not only by gendered narratives, but also by the way in which states understand and counter specific forms of exploitation, which we've seen in multiple case studies. Just to highlight, for example, in Brazil and in the Philippines, forced labor is normalized and the culture of exploitation is embedded, meaning that trafficking for the purpose of forced labor is underreported and under-addressed. And lastly, our research found that systemic discrimination and racism also shape the functioning of identification and protection processes. So in Cyprus, for example, the Ombudsman has recorded in the last years a series of practices hindering identification that were characterized and explained through institutional racism. And discrimination in the context of prosecution was also highlighted. In Bahrain, for example, where racial stereotyping may impact the government's record of convictions in relations to specific nationalities, and in particular Bangladeshi nationals, who are stereotyped as being more likely to commit crimes. Now, very briefly, before I hand over to Jean-Pierre again, two more factors have been identified, even though to a lesser degree. So religion and morality and levels of immigration. Now, clearly, religion and morality is interlinked with culture. So it impacts culture, victimhood, and discrimination indirectly. But in a few cases, it has emerged as a determinant in and of itself. So morality and religion have been found to have the potential to be positive catalysts for advocacy, which usually occurs within faith-based platforms. Yet this pressure tends to result, as far as the case studies that we've looked at, in partial improvements and a limited scope of engagement. In addition, when religion and morality are used as justification for abolitionist approaches, the resulting efforts might be detrimental for certain persons. And this was the case, for example, in Algeria, where religious pressure to shut down brothels has led to their closure, which has, however, not been followed by any other significant improvement during trafficking for sexual exploitation. The last determinant, which is levels of migration, we've talked already quite a bit about the overlay of immigration, mobility, and trafficking. However, there is an increased tendency to conceive trafficking only in connection with migration flows that risks sidelining the internal trafficking. And in addition, the politicization of trafficking has been a tool against migration effects that hinder states' anti-trafficking efforts, including an increase in migrants' vulnerabilities. And this is of a broader, which is where I leave the floor to Jean-Pierre to build on that.
Thanks very much, Naomi. And I'll move on to talk about governance, politics, and corruption as kind of the next big determinant, particularly one of the structural determinants, one of the contextual determinants. And we see that the kind of political configuration of a particular country does have an impact on anti-trafficking efforts, the way policy is adopted, the way policy is implemented, the way policy is funded, the way efforts are funded, the way practices are funded, is all affected by the way the structure of the political context, of the political structures of the particular state are impacted. That is also linked to kind of other grounds. So for example, political will, as well as corruption, etc. So just to give a couple of examples, in particular contexts, we see that the fact that Parliament was sidelined in the way laws or policies were being adopted, because they were being adopted in a way that didn't involve parliamentary participation, such as was the example in some of the Latin American countries we looked at, was seen as a negative because it didn't allow for the buy-in from the broader kind of political space, whilst in other contexts, the fact that power tended to be centralized, tended to be kind of concentrated, allowed particular individuals with good anti-trafficking credentials to really push forward a particular agenda. We also see that changes in government can have a negative impact or an impact on anti-trafficking efforts, sometimes positive, sometimes negative, whether that's moving away from governments that have particularly egregious policies in terms of, for example, migration, as Noemi was just saying, that have a negative impact on anti-trafficking, moving towards governments that have kind of more positive policies. But more importantly, sometimes what we see is that when there is a change of government, any kind of goodwill, any kind of positive developments that might have occurred prior to the election tend to get lost when people change. And this is especially the case when there is a lot of kind of power or a lot of the kind of that individual determinant side of things, when that particular person is no longer in a position where they can push that particular agenda that will obviously negatively affect the broader developments in anti-trafficking in that particular context. Adherence to the rule of law comes across as being particularly important, both in terms of, for example, how corruption impacts anti-trafficking or negatively impacts anti-trafficking, but also when we look at, for example, the correlation analysis that we did, that Marika mentioned at the start, where we looked at different indices and how they correlate to each other, we see that there is a strong correlation between a country's performance in the rule of law index with their performance in anti-trafficking indices, whether that's the TIP report or others. The other thing that comes across, which is interesting in terms of governance structures, is when you have particular parts of the country which are not under the de facto jurisdiction of the particular state. And we had two countries in two of our case study countries where this was the issue, was an issue. So it's an issue that comes across in the Cypriot report, as well as in the Georgia report, where we see that there is kind of where there is this gap between the de jurisdiction, de facto jurisdiction, or where there's effectively no jurisdiction of the state, then obviously anti-trafficking efforts in that areas and anti-trafficking, trafficking more generally tends to flourish in those areas. The other thing that we see, and this is partly related to the way anti-trafficking is presented and framed in some countries, is the role of women in policymaking. In various countries, we see trafficking, at least for a while, having been presented as a women's issue. And as a result, a lot of women in positions of power were pushed towards doing the heavy lifting in terms of anti-trafficking law and policy in those countries. And in fact, we see that in various countries, in Chile, for example, as well as in the UK and elsewhere. When we talk about corruption, obviously corruption is one of the negative determinants that hinders policy and practice across the board. It both hinders the adoption of policy in the first place, but it also hinders the implementation and enforcement of policies, and it cuts across all levels of government and the judiciary. And we see corruption as a problem both in terms of governments and government officials, but border officials, etc., but as well as in the context of judicial decisions and prosecutorial decisions, etc. So moving on, because I'm conscious of time, to international law, to partnerships. Again, partnerships comes across as being critically important to anti-trafficking. It is one of the topics that comes across repeatedly from most of our case study reports. When we talk about partnerships as a determinant, we think about partnerships both within the country and internationally. Cross-sectoral partnership within a particular country, whether that's labor organizations working with migration organizations, working with women's rights organizations, with children's rights organizations, etc., or whether that is different parts of the government working together, whether that's immigration working with kind of a human rights or civil liberties directors, whether that's labor inspectors working with others, with the kind of more traditional anti-trafficking stakeholders within a particular government. However, we see partnerships as being important also at the intergovernmental level. So governments working together, whether that's in terms of delivery of training, for example, or sharing of expertise, whether that is collaboration in terms of joint investigations across countries, whether that's collaboration in terms of funding of particular projects or development of projects together, etc. A lot of that partnership does get channeled through international organizations, and the contribution of international organizations in the space has come across as being particularly important. And then related to this, although not technically a partnership, is the question of regional competition. So one of the things that comes across, and it came across in the report from the Bahamas and the report from Algeria, for example, is that regional competition, wanting to be the first in the region to do something, wanting to be better than our neighbors, and that comes across quite clearly as something that promotes political will and promotes positive anti-trafficking efforts, which, whatever works in some cases. The other thing that comes across, and going back to the cross-governmental work, is the role of specialized anti-trafficking institutions. And we originally had specialized anti-trafficking institutions as one of the outcomes that a lot of the determinants were pushing at. But actually what comes across very clearly from our research is that those specialized anti-trafficking institutions are also determinants of other efforts, because they do bring people together. They do try to push, in many cases, they try to collect data and share that data. They try to push a particular understanding of trafficking that is then shared across the different stakeholders within the particular country. The other thing to say about partnerships is that where those partnerships fail, and when partnerships don't exist, and you have different parts of government using or adopting different understandings of trafficking, for example, that is obviously going to result in failure in those anti-trafficking efforts moving forward. Speaking of partnerships and organizations and countries working together, the role of international law was another determinant that comes across quite clearly, which we were happy with, considering our role and the institute that we come from. But I think when we talk about international law, we really see some of the kind of, we see a positive determinant that has a lot of limitations as well. Potentially given, well, first of all, international law is both an outcome and a determinant. The fact that a country signs up to an international instrument is itself an outcome of all the other determinants, whether that's kind of pressure by civil society organizations, whether that's case law, whether that's political will by particular individuals, etc. But it is also a determinant of other efforts. And most countries implemented or developed domestic legal frameworks in response to, for example, signing up to the Palermo Protocol. The Palermo Protocol gets highlighted obviously throughout, and this is for obvious reasons. Regional instruments also get highlighted, obviously in particular regions where, in particular countries which are parts of regional frameworks that have specific anti-trafficking instruments. But when it comes to the Palermo Protocol, I think there are two areas where the Palermo Protocol is seen as important. The first one is with regards to framing, how we understand trafficking. There we have a bit of a mixed bag. we have framing of trafficking as being wider than trafficking for sexual exploitation, which was the previous understanding. But at the same time, we still have this emphasis and this focus on the specific situation of women and children. So there is that kind of limitation of that framing, as well as framing of trafficking as a criminal law, organized criminal law issue, rather than kind of a broader human rights issue, etc. And the other way in which the Palermo Protocol is particularly influential is obviously the standards that it sets, but also, and again, this is the other limitation, is the standards it does not set, especially in the context of victim protection, etc. So we then have regional instruments and soft law instruments that push some of that agenda forward. So we see regional instruments and soft law instruments pushing victim protection a lot further than the Palermo Protocol does. Interestingly, whilst regional instruments were seen as being particularly important, soft law instruments came across as being a bit less important, or at least they weren't identified particularly as being important. And I think one of the reasons for that is that soft law instruments are very much seen as a way to implement our obligations under the hard law instruments, whether that's the protocol or other regional instruments. Obviously, international law influences anti-trafficking efforts in the trafficking instruments, so the protocol, etc., but also through other frameworks within international law, whether that's human rights law, whether that's labor standards, etc. All of those developments in those areas, international obligations, international standards being developed in those areas are seen as being a positive influence on anti-trafficking efforts in particular countries. Again, international law doesn't act on its own. Its influence is affected and channeled through domestic legislation, domestic case law, the willingness of particular courts, for example, to rely on obligations coming from regional instruments, from international instruments, as well as civil society engagement, the way civil society uses international obligations, soft law instruments, etc., to push for changes at the domestic level. So that's very broadly on international law. Moving quickly on is external monitoring, which is again very much linked to international law because a lot of the external monitoring is linked to specific instruments. Obviously, one of the main things that comes across is the importance of those external monitoring processes on anti-trafficking efforts. Everyone, most people who reply to our survey, for example, most of our country reports all talk about external monitoring as having an influence. The different countries will have different levels of influence by different monitoring bodies, and obviously different monitoring bodies will engage with different countries than others. The US TIP report, the ranking of a particular country in the TIP report, interestingly, the ranking in and of itself almost more so than the broader context of the TIP reports. The Greta reports in the Council of Europe space, reports by UN treaty bodies, special procedures, and others all come across as being particularly influential. And one of the ways in which they are seen as influential, and this comes across especially so in the context of special procedures and UN treaty bodies, is the engagement, the longer term engagement between that monitoring process and the particular government, the people working within government, understanding that process and making sure and engaging kind of over the longer term on the improvements at the national level. The relevance of external monitoring is both direct and indirect. Obviously, sometimes states will react directly to the particular monitoring report, etc. But also it allows civil society organizations to engage and use those recommendations actively at the domestic level and actually have the backing of that external monitoring process to push for that particular agenda. The other thing is civil society organizations will often feed into those treaty body processes, those Greta reports, the US TIP report, etc. There are processes through which the various monitoring processes engage with civil society organizations at the domestic level. And obviously civil society organizations, depending on their level of engagement, their level of their space, their ability to engage because of resources, etc., will also be able to feed into the monitoring processes and then take away from the monitoring processes to use in their own work. External monitoring is influential because it affects the international reputation of states. And I think that is particularly important. And political will, again, very often we see political will coming into play, not so much because we want to improve our anti-trafficking efforts, but because we want to be seen as a good player on the international scene. And therefore, there is that political will that kind of gets triggered by external monitoring processes. External monitoring gets criticized for a number of reasons, some more legitimate than others, whether that's the legitimacy of the monitoring process itself, whether it is seen or at least presented as being an interference by foreigners into domestic affairs, or whether it is presented as lacking an appreciation of local realities. And it is these foreign people who don't understand our local reality that are pushing these particular recommendations. External monitoring is also particularly influential when there is a threat of sanction. So the fact that some external monitoring processes include a threat of sanction, which might actually link to issues around kind of economic participation, etc., will also have a strong impact. I've mentioned regional competition before. Those external monitoring processes are seen as a way to compete in some ways and as kind of the markers in that competition. And the other thing, and I think this applies to civil society organizations as well as to many governments, is the idea of monitoring fatigue, that in some cases you have 3-4 different bodies kind of looking at some aspect of anti-trafficking in the particular country in any given space of time, in any given year, for example. And there is kind of this kind of feeling that we're constantly engaging with these monitoring processes, but what are the changes that we're seeing at the domestic level? So that is another kind of weakness of external monitoring, or something that external monitoring processes need to keep in mind in order to ensure that they keep their role as a determinant of positive anti-trafficking efforts. I think that's me passing on to Noemi now.
Thank you, Jean-Pierre. Just a few more, and I'll try and be very brief and go by key points. So case law has been identified again as key, that yet just like other determinants is determined among other factors by a state's political situation, the rule of law, and levels of corruption. Now, international case law, and in particular the judgments of the European Court of Human Rights and the Inter-American Court of Human Rights, have played a significant role in clarifying and underlining states' positive obligations. For example, in Brazil, Cyprus, and the UK, among our case studies, with ripple effects on other states' parties to the respective conventions. At domestic level, the presence or absence of judgments is linked with a state's identification and action process, as well as with the awareness and competence of law enforcement and the judiciary. In some jurisdictions, case law, or even the simple filing of a case or the beginning of a case, coupled with media exposure, has been fundamental. And the compensation scheme were introduced following domestic courts judgments in Thailand and in the UK. In other jurisdictions, for example, Bahrain and Guyana, case law was not found to be determinant. In Bahrain, arguably or allegedly due to its civil law system, even if Argentina shares the same type of system, and yet case law has been a key determinant. And in Guyana, due to the lack of access to written judgments. In Chile, on the other hand, case law was found to be a partially negative determinant due to lack of training and expertise, and consequently a series of poor judgments being issued. I will move on to CSOs because it is quite a determinant, and civil society organizations are other actors playing a key role in exerting pressure on governments. And while we understand the trade unions and survivors groups as part of our definition of CSOs, the literature is quite sparse regarding their role, and unfortunately, our case studies reflect this pattern. And with the exceptions of Algeria, Bahrain, and the Republic of Cyprus, where there are no specialized anti-trafficking CSOs or where CSOs are heavily silenced, our case studies have revealed a generally positive impact of CSOs on anti-trafficking efforts. Now, in their expert capacity, CSOs can participate in policymaking, legislative processes, and judicial cases, providing inputs and feedback about the adoption, the implementation of legislation and policies. In practice, we've seen these in Armenia. They can be involved in high-level specialized institutions, as we've seen in Argentina and Chile. They can intervene before domestic and regional courts, as it was the case in Brazil and the UK. Or they can transfer knowledge and to the state.
Noemi, I think we're losing you slightly.
For example, as Philippines, as hear me? Can you hear me now?
I think you're back. Yeah.
Okay, sorry. I was going from the specialized knowledge and expertise into advocacy, and just saying that can vary quite substantially.
Sorry, Noemi, you're
on the
breaking up
basis
again.
of the degree of freedom that CSOs enjoy in this. Sorry.
No, not your fault, it's the internet. But JP, maybe you could take
Maybe
over.
I can take
come
over
back.
for a little bit.
Just
Sorry.
a time warning. Well, thanks.
Yeah. So I think what Noemi was trying to say at the end there was that civil society engagement is very much dependent on the level of freedom or unfreedom that civil society organizations enjoy in the particular country. And we see a number of kind of situations where that's the case, where civil society organizations are particularly able to engage, feel particularly safe in engaging, feel like their engagement will actually have an impact, and they're very active, whilst in others, they feel like they might be able to engage in service provision, for example, for the government or alongside the government, but they might not feel able to engage at the policy level, at the advocacy level, because of various reasons. And that came across in various countries. So for example, in the context of Argentina and Chile, we see kind of this willingness to engage, this ability to engage, this kind of freedom to engage, whilst we see kind of limited space and counter engagement, I would say, with civil society in countries like Cyprus, Algeria, and Bahrain. So just moving on quickly to the economic conditions in the particular country, we see that obviously the availability of resources is particularly important, but again, the decision to allocate resources to a particular anti-trafficking policy, to a particular anti-trafficking space or policy field is itself a political decision, right? So just because the country has the resources generally doesn't mean it is allocating them to anti-trafficking efforts. And in other contexts, when there are difficulties, where there are economic difficulties in the country and there is still allocation of resources to anti-trafficking, that is a good sign that there is genuine and substantive political will to keep things moving forward. The other thing that comes across quite clearly on economic conditions is the reliance on exploitative industries. And we see that in various countries, there is an economic reliance on particular industries, and therefore a reluctance, to put it nicely, by governments and by kind of prosecutors, etc., to go after exploitation in those industries and trafficking in those particular economic areas, because there is a dependence on that funding. And that could be particular industries. It could also be particular types of migrations or migrations to particular places when there is a reliance on remittances, or where there is a reliance on particular aspects of tourism, for example, etc. The other thing that's related to economic conditions is the question of external funding. And one of the things we see is that external funding is a positive determinant for anti-trafficking efforts in most countries. It also allows it allows a certain kind of sustainability of some anti-trafficking efforts when there is a change of government, for example. But the other side of that is when it comes to external funding, a lot of it is project-based, and we see this kind of projectization of a lot of anti-trafficking efforts in many countries being a problem, especially when donor interests change after a while, when something else comes up and suddenly all donor interests go to that particular area. And the threat of loss of external funding is itself a determinant for countries to keep moving in a particular direction. Okay, so moving on to events and crises. Again, we kind of put these two together, but actually the impacts are quite different. So starting from the second part of the slide where we talk about events, most of the literature, most of the interviews that we did mention sporting events rather than others, but there might be other events as well, which might increase the demand for services by trafficked persons, and can result, especially when linked to media attention, for example, in increased attention to anti-trafficking, and very often in at least a semblance of more efforts to deal with trafficking. However, one of the things that comes across quite clearly is that very often those improvements are short-lived and short-term, and they're not particularly sustainable. The other side of this is emergency situations, things like conflicts, natural disasters, etc. And one of the things that we see is that in those contexts, anti-trafficking is affected, in the most part, affected negatively because of two things. One is the breakdown in the rule of law, in kind of the general adherence to the rule of law, but also that anti-trafficking gets deprioritized, both in terms of resources, but also in terms of policy attention that is given to anti-trafficking. It's not always seen as one of the immediate problems that need to be addressed when other issues such as housing, etc., need to be addressed right away. Obviously, this is particularly interesting, important, and disappointing, given that in the context of emergency situations, the risks of trafficking are very often increased because of exactly the same things: the breakdown of the rule of law, the fact that there isn't kind of attention given to preventive efforts, etc. Even when there is attention given in context of emergencies, very often they'll be limited to a specific type of response to trafficking. And moving on to one particular type of emergency, which is COVID-19. We started this project before COVID-19 was as big a thing as it is now, or as it was at least for the past 2 years. But obviously we did want to look at COVID-19, but we did want to look at COVID-19 slightly separately from other determinants. The only reason being that when you start talking about COVID-19 in the same way as a few other issues, it tends to become the only determinant that people will identify. But I think in the context of COVID-19, we see that a lot of the determinants actually remain the same, even if there were new vulnerabilities that came across. We see very practical challenges in terms of the implementation of anti-trafficking efforts, but we also see the importance of partnerships, especially local partnerships. The partnerships with civil society organizations, the way civil society organizations are seen, whether they're seen as first responders, whether they're seen as essential workers, etc., etc. And the other thing, and I'll conclude on this because I know that we're over time, is that unfortunately all too often things like COVID-19 and other emergencies are used as a pretext to not do things that countries didn't want to do anyway. And countries as well as others will use COVID-19 as a pretext for for not doing the things, even though they wouldn't have done them anyway, even if COVID-19 was not there, or if COVID-19 does not really give the justification for not doing taking those particular measures. And I think that brings us to the end. Noemi, I think your sound is working again now, so I don't know whether you wanted to add anything.
No, it's all right. You've said it all.
Thanks both, and sorry, Noemi, technology is what it is. That was amazing, both of you. Thank you, Jean-Pierre and Naomi, for distilling so much nuance into such a cohesive presentation. So the picture now so very vividly painted, I'd like to turn now to our discussants and invite them to offer their reflections on these findings in 10 minutes or so, and share what they've found insightful, useful, concerning, or otherwise. We are behind time, so I don't have time to do justice to the introductions and give these people their due. But to start us off, I'm very pleased to introduce Martina Vandenberg, who is the founder and president of Human Trafficking Legal Center. For more than 2 decades, Ms. Vandenberg has been fighting human trafficking, forced labor, rape as a war crime, and violence against women. As an attorney, she's represented victims of trafficking pro bono in immigration, criminal, and civil cases, and has testified before the Senate Judiciary Subcommittee on Human Rights and the Law, the Helsinki Commission, the House Foreign Affairs Committee, and the House Armed Services Committee. She's also the author of 2 Human Rights Watch reports and has received multiple rewards for her efforts against trafficking. She's also a Rhodes Scholar and a Truman Scholar, and has taught at the American University, Washington College, Oxford University, and of course in her capacity at the Human Trafficking Legal Center has trained literally thousands of pro bono attorneys. I obviously could go on, but far better to hear from Ms. Vandenberg herself. Martina, for 10 minutes or so, the floor is yours.
Terrific. Thank you so much. And first, let me just begin by congratulating all of you, because this was an enormous undertaking, an enormous body of work. And there's clearly really keen analysis that has gone into this report. So I just want to start by saying that, and then I want to say something a little bit contrarian, which is when you address housing, you are addressing trafficking. Because we have been focused for 20 years on the wrong P, right? We have been focused on prosecution, and Palermo drove that. And I was at those negotiations in Vienna in 1999. And we really believed at that time that we could prosecute our way out of human trafficking, and we were wrong. And if we are waiting to prosecute our way out of human trafficking, we are waiting for Godot. And so I really want to go back to fundamental principles. And you have asked the question, what drives policy? What are the determinants? But I want to take us back down to basic fundamental principles and ask, where are we driving? And are we asking the right questions? And are we driving in the right direction? Because I think the answer is no. The word that comes up in the report frequently, the phrase is culture of impunity. And that is true. I want to tease out 4 of the determinants that I think were most meaningful to me in reviewing the report. But then I really want to come back to this question of a reckoning for the human trafficking movement, a reckoning for human rights lawyers across the globe on these issues. And I'll start with one of my favorite determinants, which is corruption, because I think corruption drives so much of this. And corruption is part of what makes prosecution impossible. The report cites specific case studies in Chile, border police taking bribes, in Mozambique, police who are literally on the payroll of the traffickers. In the Philippines, this pastilla scheme where any Chinese worker crossing the border comes across with a fake piece of candy wrapped in white paper that's actually just a bribe. When you have law enforcement involved in the trafficking, when corruption persists with impunity, how on earth do you expect that there could be prosecutions? I often point to the history of bribery. I think looking at the determinants of what ended the tolerance for bribery around the globe should really in some ways be feeding much of our discussion. Bribery used to be ubiquitous. In Germany, bribery was tax deductible as a business expense. And that changed. Some of you may have seen the announcement from the US Attorney's Office yesterday in the Southern District of New York of a $1.5 billion fine, a 1.5 billion with a B dollar fine against Glencore for paying bribes. And the prosecutors basically said that bribery is in the DNA of this particular company. And that is why they face this criminal penalty. If we are going to do criminal prosecutions, it cannot be a bad apple criminal prosecution strategy. We need to be prosecuting corporations. We need to be prosecuting the heads of corporations. We do not need to be prosecuting small individual traffickers who are at the very bottom of the chain. We have focused on prosecution. I'm not saying we should abandon it, but we have focused on prosecution at the very, very bottom of the chain. We have not looked at the systemic and structural issues. And the report makes these points as well. The second determinant that I just want to focus on, because our organization has done work on this, and I was so thrilled to see it in the report, is racism and discrimination. You cite the example of workers coming into the Philippines, trafficked from China, who are described by that government as illegal workers and not as trafficking victims subjected to forced labor. There is enormous racism pervading the anti-trafficking movement. And as you point out in the report, there is the conflation of anti-immigrant policy and so-called anti-trafficking policy and the cynical use of anti-trafficking policy by governments to block immigrants from entering and asking for asylum. The example that you cite in the report of the funding project in Nigeria, funded by DFID, a program that was turned into a video telling Nigerian women not to migrate. Again, do not migrate is not an anti-trafficking strategy, but governments have completely twisted this and turned smuggling into trafficking and then blocked all entry of migrants onto their shores and said that they're fighting trafficking, which is, again, unbelievably cynical. You cite this term crimmigration in the report, which I think the criminalization of migration, that's exactly what's going on here. The third determinant that you point to is the kind of naming and shaming, what I used to do at Human Rights Watch. The naming and shaming piece, the tip report, the competition, all of that, but you rightly point out that this gives rise to superficial changes, sometimes inflated and fake prosecution statistics in order to move up to tier 1 in the tip report. You point out that the tip report is properly criticized for not pushing for structural changes. One of the things that my colleagues and I frequently say is that forced labor is a feature and not a bug in global supply chains. It is a feature in the global labor migration system. The system is working exactly as it is designed. And if that's the case, we're not going to prosecute our way out of it. We need fundamental structural change to prevent this. And again, P is the forgotten P is prevention. The last determinant that I want to point to in my limited time, and there could be lots more to say, and I really want to hear from Siobhan from the Special Rapporteur. The last determinant that I want to point to is what you call case law, but what I would call strategic litigation, because there are people, lawyers around the globe, in the UK, in the Netherlands, in Germany, in Australia. There are lawyers, even in the United States, who are doing everything we can to litigate these cases, realizing that governments have failed. The states have failed. They signed up to prosecute and then they didn't do it. And so if we are to have any kind of positive outcome and structural change, some of that will be driven by strategic litigation. And just to give an example, here in the United States, We've been litigating these cases, mostly forced labor cases, because the US government brings almost no forced labor cases, and really no forced labor cases against corporations. So we've been litigating these cases for since 2003, when it became possible to do so. And the last time we did a head count on all of the verdicts and the public-facing judgments and the public-facing settlements, the confidential settlements obviously aren't included in this number, we discovered that there's been about $250 million, so $250 million in damages and compensation for victims. $250 million makes corporations sit up and pay attention. But we are due for a reckoning. And I think the tools that we are using are different. Again, we're not abandoning prosecution. We're just admitting that it is not the magic bullet that everyone thought it would be when we were doing the negotiations in Vienna. It was the one thing that states could agree on. You have pointed out that political will is also all about resources. The question is, how are we using these resources? And I just want to point to one new tool that we're using in the United States and that is growing around the globe, and I'll close on this. We are now using trade remedies, because the question is, how do you force corporations to take notice? How do you change the systems? How do you change the structure? How do you make forced labor no longer profitable? And last year, using trade remedies, the US government blocked more than 1,468 shipments of goods tainted with forced labor intended for US markets that were turned away or detained. That was $500 million worth of goods in 1 year. This is beginning to make a difference. I'll close with a funny statement from a colleague, David Feingold. Many of you may know him. He's an anthropologist who's worked for years and years and years in Thailand and has written widely on this topic. And David Feingold, also a critic of how this movement has evolved over the last 2 decades, was in a meeting talking about the new statistics around the globe that had been just released, that before it was 20.9 million, now 10 years later, it's 40.3 million. How did this happen? And David Feingold said, you know, human trafficking, the more you spend, the worse it gets. So I think that sense that we are using resources and perhaps using them unwisely causes us to really look at this report, look at these determinants, and think, where are we driving? Thank you.
Thank you, Martina. I couldn't agree more with your call for a reckoning, and I salute every point you made in that. Turning now to Professor Siobhan Mullally, who is, of course, the UN Special Rapporteur on Trafficking in Persons, especially in women and children, a role she's been very generously fulfilling with prolific presence around the globe in person and online. And so we're grateful for your time today, Siobhan. Professor Mullally is the established professor of human rights law and the director of the Irish Centre for Human Rights at the School of Law, National University of Ireland, Galway. From 2012 to 2018, she was a member of the Council of Europe's Greta and served as its president from 2016 to 2018 and vice president from 2014 to 2018, in which capacity she was co-rapporteur for a range of country evaluations. She's worked with international NGOs and UN agencies around the world, from Pakistan to Ethiopia, from Timor-Leste to Kosovo and Kazakhstan. And from 2014 to 2019, she was the commissioner of the Irish Human Rights and Equality Commission and member of the Good Friday Agreement treaty body, the Joint Committee on Human Rights of the Northern Irish and Irish Human Rights Commission. And she's also a member of the Permanent Court of Arbitration, The Hague, and joint editor-in-chief of the Irish Yearbook of International Law. Siobhan, as always, your views are highly valued, and I'm delighted to pass the virtual floor to you.
Thank you very much, Marika, and thank you very much to the British Institute of International and Comparative Law for the opportunity to join you. Congratulations to Jean-Pierre and to Noemi on the publication and launch of the report. As Marika said in the introduction and opening, the report is ambitious in scope and really provides an in-depth study of what is influencing and shaping what states do to combat trafficking, why they take certain actions, why they don't take others, what is influencing and shaping those choices and decisions, and what is influencing the process of legislative and policy reform. It's a hugely important study in that it's really bringing us information around what's happening in specific regional contexts and specific country contexts. And 2 decades after the adoption of the Palermo Protocol, it's raising questions as to what really are the key determinants in furthering anti-trafficking action. From my perspective, in terms of my current mandate as UN Special Rapporteur on Trafficking in Persons, I was obviously particularly interested in the questions around the role of international law, of the influence or otherwise of UN special procedures and human rights treaty bodies, regional bodies, and the whole role of external monitoring, including questions around the threat of sanctions and how that can act as a push factor in terms of shaping anti-trafficking actions. And of course, as is noted, we find in some contexts that international law, external monitoring, the role of UN special procedures may be influential, but it's very much dependent on context. So I thought it was interesting that it's noted that it can be more influential where it's perceived as a process of constructive engagement, for example, or where there's a very specific point in time where there's ongoing debate in relation to a legislation and policy reform or new development. And I think that is quite important because for UN special procedures, for example, we have a global mandate, very limited resources. So it's really important that those key moments are brought to the attention of a special procedure or a monitoring body, and that there is engagement from the ground. So the importance there of civil society, of policymakers, knowing how to and being able to engage with UN systems or regional bodies to leverage that kind of influence or support. Excuse me. I also thought it was interesting around, the key influence of the Palermo Protocol. And as Martina said, we have tended to focus, and a lot of international action has focused on seeking to strengthen investigations and prosecutions to combat impunity for trafficking in persons. Despite this emphasis, however, we see that impunity remains, that there is in fact very limited accountability for trafficking in persons. In particular, I would say in conflict settings in the context of atrocity crimes. That also raises questions around the shortcomings of the Palermo Protocol, as are noted in the report, that it was a groundbreaking instrument at the time that it was adopted, but it is relatively weak in relation to the obligations imposed on states around assistance to victims and protection of victims. So regional instruments and often domestic legislation is much stronger. But given the global influence of the Palermo Protocol in terms of shaping legislative developments, I think that does raise questions around how can we build on that? What more can be done? And here, I think there are questions as to, and these are raised in the report, the relatively limited engagement by UN human rights treaty bodies with questions of trafficking in persons. Beyond the reporting process, where we do often see in the periodic reporting, in the concluding observations adopted by states, we do see attention to trafficking, but not systematically or not consistently. And we are not seeing attention to human trafficking in the individual complaints procedures. And again, I think that is of concern, given that because the Palermo Protocol is relatively weak on the human rights aspects in relation to the rights of victims and survivors and the positive obligations on states around assistance and protection, we really need to be able to leverage international human rights law and regional human rights law to greater effect. And one way of doing that can be through the individual complaints procedures or the other procedures available to treaty bodies, such as inquiries or country visits. So again, I think that's a lesson that perhaps we need to think a bit more about. And also at regional level, we have seen very important landmark judgments which are analysed, in particular from the Inter-American System and the Council of Europe, the European Convention on Human Rights and Court, drawing on the Regional Anti-Trafficking Convention of the Council of Europe. But again, we do need to think more about how to build on the work that's been done within ASEAN and within the African region in terms of the human rights system there, whether that might be influential, or what role might other bodies like the African Union play, for example, or the Peace and Security Council of the African Union. I thought the points around political will were very well made, including in terms of who are the key actors, not just the politicians as such, who we tend to think about, but also the importance of key policymakers, key partners within civil service positions who may be there for a longer period of time. In Ireland, we refer to them as the permanent government, but those can be key partners in terms of shaping change and seeking to influence change. And I think that's really important to think about that, but it also raises questions around the relatively siloed approach that we sometimes see, and that trafficking is sometimes looked at as an immigration or home affairs or justice department issue, but isn't always looked at in a cross-cutting way in terms of who are the key political actors. Again, I thought the points around framing are very important here, in terms of that trafficking is often framed as being transnational, as being a criminal justice concern, and very much in individualized or individualistic terms. And the consequences of that, of course, are seen in the lesser attention paid to internal trafficking, that it's not always identified or recognized, that we don't see the same engagement in terms of anti-trafficking efforts. And also, I think in terms of what's missed in terms of large-scale movements of people, whether it's those who are internally displaced or large-scale refugee movements. So we know at a global level that trafficking is often missed in terms of refugee settlements or internally displaced person settlements. That has changed a little bit, I think, in looking at the responses to the war in Ukraine, but that hasn't been the case consistently. So, and again, it highlights who is engaging, that because we have tended to think about human trafficking in terms of individualized human rights violations, we're not always engaging as we should do with humanitarian actors, for example. And that leads to weaknesses in practice in terms of capacities around identification and protection, but also weaknesses in terms of prevention. And we see that also more broadly in armed conflict settings, I think, despite important work done by Marika and others around trafficking in conflict settings. And finally, just to note, I think the points are very well made and were highlighted already also by Martina around culture, victimhood and discrimination, who is recognized and identified as a victim of trafficking, who is considered to be credible, who is believed, whose testimony is believed, who is identified as a victim of a serious human rights violation and a serious crime, and who is not identified and given assistance and protection. So the gendered stereotypes, the fact that we may miss adolescent boys and adult men, who fits the stereotype of the ideal victim, a woman exercising agency or choice may not be recognized or accepted as a victim of trafficking, and the systemic racism that hinders identification of victims at borders and within states, and repeatedly leads to failures of protection. And that, I think, really needs to be highlighted, and important work has been done by the Human Trafficking Legal Centre also on that. And just to conclude, partnerships were repeatedly mentioned as being important. I think this work, in terms of bringing together a range of different actors, in itself is an important partnership, and we need to continue to recognise the importance of the role of civil society, as is highlighted in the report, but also to recognise that civil society, including trade unions, are often under pressure within states. And in particular, that can include those working with migrants, and also those working with workers who may be in vulnerable situations, in irregular situations, or who may be challenging very powerful actors. So I think those partnerships and the recognition of the importance of those partnerships is something to highlight as well. Thank you.
Thank you so much, Professor Mullally. These have been such enlightening insights. I'd just like to remind the audience that the next session will be Q&A, so please use the chat function to pose any questions to our speakers, and we will get to those. Limited time, however. I have also been very kindly invited by the British Institute to offer my own reflections. I'd like to respond to a point I couldn't agree more with that was made by both Martina and Siobhan about how, my words, disappointing the protocol has been. I think we can all agree on that. And had we had our time over, if we could go back in time, I think we would come up with something quite different. I don't mean to defend the protocol, but I think I'm a bit of a pragmatist, though, in that it is here to stay. And I do also think that if we had the interpretive will to do otherwise, we could do that. If we had the interpretive will to make sure that we're implementing it in a human rights-based way, we could do that. To your points, Martina, as well, we need to be prosecuting corporations. The protocol does push for prosecution of legal persons. It does try to elevate our criminal justice targets to being transnational organized crime based. It's not frivolous. It has become so through the way it is being interpreted, or another way of looking at it would be the way it is being misinterpreted and implemented in ways that I think are not fulfilling its potential. So I couldn't agree more with you both, but perhaps it may be premature to give up on the protocol itself, and we may just have to suck it up, as it were. Again, congratulations to both of you on this report. I think it's an extraordinary achievement, and it begs us to ask, as part of designing our own counter-trafficking strategies, we need to ask, why would a state want to act? And as you said, Martina, things are working as they are intended. So that means that we cannot take for granted that a state will act merely because it's positively obliged to act. And nor can we assume that governments, who at the end of the day, let's be honest, governments are just groupings of individuals with diverse and sometimes competing priorities. We can't assume that they will take action just because they care about trafficking, if indeed they do. They might not, but there may be issues that stop them from taking action. And I think, so now we know that it's naive and unrealistic to have these assumptions. And that may in fact speak to some of our innocence in the past, where, we now know that raising awareness is pointless, where the people whose awareness we are raising are powerless to act. So the study, I think, really challenges us to get better at understanding who has the power, what is the extent of that power, and what can incentivize them to use it. I think we're all unsurprised to learn that there's no one lever to pull, but there are nonetheless a series of levers, and you've given us a kaleidoscope of economic, cultural, social, political, and institutional factors. I think a striking point to me in all of this is that they're context specific, and that what may be a determinant in one place at one time may shift. And here I think we also have to note that how do we acknowledge that political will is key, and create and cultivate it in context. And I think when it comes to how things are understood and framed, we will be contending with definitional conundrums for all eternity. One of the points that emerged to me looking at the reality that states often use counter-trafficking as political currency, I think the question for us in the counter-trafficking world then becomes, do we call them out and remove that tool from them, or do we help shape how they wield that tool? And again, the answer to that question is a matter of context. And I think on all the determinants, you really challenge us to raise many questions about how we're doing the things we do. We know that media is critical in framing and response, yet how many counter-trafficking undertakings have an informed media strategy as part of their plan? Very few that I've been involved with. You know, data and research, such that it's largely a tool of external actors to influence governments, is powerful but limited. So what then of our efforts to support the government's own data collection capacity so that they can own and see the issues themselves, as indeed they're obliged to do? Your questions of culture too raise so many questions for me, not just in relation to the dominant culture of the state, but also those minority cultures within it. And here I think even well-meaning states are hugely challenged with questions of whether applying the same standard is the right or the wrong thing to do when something as subjective as human exploitation is at issue. I think the points that are made about corruption, and Martina touched upon them too, and the same points she made about housing. Addressing housing is to address trafficking. The same is true of corruption. We know that corruption fuels trafficking and a host of crimes that are related to it. And we know that it disincentivizes action against it. But what are we actually doing with that knowledge? How diligent are our counter-corruption efforts? On the role too of specialized anti-trafficking institutions, I think I need to really chew on the food for thought that you've given us here. And in my own travels in trafficking, I've encountered really different scenarios. At best, I think we've got institutions that have been critical in bringing together comprehensive multi-agency responses. But at worst, I've sat down with agencies who are part of specialized anti-trafficking bodies who are very unaware of that fact. And importantly too, I think we need to ask, this push that we've all done towards specializing counter-trafficking, is the risk then that we've actually diminished responsibility and capacity to mainstream counter-trafficking where it is encountered? And I come across that constantly when I'm engaging with criminal justice response. I was also heartened to learn of the positive influence of international and regional law, and yet I'm often struck by how unfamiliar so many practitioners are with the frameworks that they are obliged to implement. And to the point of external monitoring and threat of sanctions, I think this has been well discussed, and I commend the JTIP office for championing this project, knowing that the TIP report would fall so squarely in its purview. And I think your findings really speak to the weight of responsibility that falls on that report and its tier ranking system, and indeed other reports, to ensure that monitoring efforts are context informed as much as they can be, and that their metrics really measure impact, and also that they take some responsibility to call out those hollow gestures and superficial responses, and indeed actions that may be harmful, where they're just counting prosecutions that, you know, as Martina points to, are not the ones that we need to be pursuing. Finally, very gratified to learn that training was a positive determinant, because my word, haven't we done so much of that? I think, though, your report does call on us to figure out how we can sustain what we're doing. And I think we really need to ask here whether training is actually capacity building. We use those terms really lightly, but I think there's a treadmill here that we might want to jump off, but need to figure out what else to do in its stead. So yes, to end on my reflections, I think the key point to me that emerges from this report is that counter-trafficking response can really be much improved if it's informed by an understanding of what determines positive action, and an honest, as Martina puts it, reckoning of what does not. And on that note, I'll return now to my role as chair and invite questions and comments from the audience. And I'm glad to see that we have some. So I'll start with the question from Alana Wheeler, who says that this is an excellent study and very comprehensive, and asks, and this is perhaps a question for you, Jean-Pierre and Noemi, would these findings be proposed to the external monitoring agencies so they can adjust how they monitor and assess countries?
Yeah, I think there's a very short answer to that, which is yes. We are in the process of finalizing the report based on the conversation today. Effectively, that will then be shared with all the stakeholders that we've engaged with in the course of the project, but also others that we might not have had the opportunity to engage with. And the hope would be that it will inform their thinking moving forward. So yeah, the short answer is yes to that question. And I think there's a kind of related question slightly further down with regards to recommendations to particular states, policymakers, donors, monitoring bodies, etc. And I think the short answer is the same there. Most of our recommendations will be kind of at the comparative/international level, not at the particular countries that we had as case studies, but a lot of those recommendations will be similar or will apply and can be used by civil society organizations. We would hope to apply them at the domestic level as well. Again, because those determinants have to be context specific and understand the particular local realities.
Thanks,
so
Jean-Pierre.
Hopefully that answers two questions in one.
Yes, indeed it does. Also, to the point of civil society organizations, Catherine Baldacchino was very enthused to see the positive impact of civil society organizations and wonders whether there were any reflections or examples of where they can still be effective despite limited funding and resources and reluctance of authorities to engage. And of course, I also invite Martina and Siobhan to contribute any responses to that.
Noemi, do you want me to take that? Or I think there's I
was just to say I can try maybe turning my video off. Yeah. I hope that works. I'll try and be brief. So among the case studies, there weren't many, as you, Catherine, might imagine, situations where without funding and without political will to listen and engage with CSOs, they were able still to push for anti-trafficking efforts to be improved in the country. However, when we talk about partnership, we also talk about international partnerships between CSOs and NGOs. And I think that this might be a way through which absence of either resources or engagement with the government can be slightly shifted. So it is the partnership element, but rather than it being intergovernmental, it is between either CSOs and other CSOs at international or different level or in different states, and potentially external funders, if those CSOs have access to them through the network of CSOs that they're part of. If you want to add anything, Jean-Pierre.
I think Martina was going to come in.
I just wanted to add that we are seeing a transformation of the anti-trafficking movement and a transformation of the non-governmental organizations that you cite in the report. And you, at the end of the report, talk about the importance of trade unions and survivors. The transformation that we are seeing is that survivors are beginning to lead this movement. It has traditionally been led by lawyers and advocates, but survivor leadership is now a core principle that is being developed by the movement. And you can see it in the rise of organizations like Survivor Alliance, led by Dr. Minh Dang. You can see it in the appointment of Sophie Atiende as the head of GFEMS, one of the largest foundations working on anti-trafficking work. So we are at an amazing moment of transformation of leadership and transformation of the entire movement, but also I feel like bringing trade unions and bringing survivor leaders into this discussion, we will eliminate some of our own blind spots, the blind spots that brought us to where we are today.
Sorry, I couldn't agree more with that. And I did just want to add one quick point to Noemi's answer before, is that one thing that we do see and that we can see more of is engagement by civil society organizations that might not have direct access at the national level, trying to influence or at least pass on their message through the international scenario, where it's a lot harder for a government to ignore or to completely, for a government to completely not answer a call from a special rapporteur, a call from a UN treaty body, etc. And there are those processes through which civil society organizations can pass their messages on to other actors that might also be able to use that information, use that country context, that country knowledge, that understanding at the domestic level to develop and push for recommendations that are applicable to that country and that push the agenda that those civil society organizations might be unable to push directly themselves.
Thanks all for your response to that, and Catherine for your question. Irina Loria has asked a very good question of how we can link anti-trafficking efforts with business and human rights and due diligence. I can feel the opinions on the call. So who would like to start?
Siobhan?
Yeah, thank you very much. I'm happy just to comment briefly. I mean, I think several others, including the Institute itself, has done a lot of work on this, and the Human Trafficking Legal Centre. I think we really need to ensure that due diligence requirements are mandatory, that it's not based on voluntary self-regulation, and that it's meaningful in terms of the requirements around consultation, engagement with communities affected and trade unions and workers, and that we see reporting also on the outcomes of those and any remedies provided where there are violations, but really concrete, detailed, in-depth reporting, and not just what we have sometimes seen where corporations or large companies can manage these requirements and have big legal teams to assist them in doing that. So I think these are really important tools. The draft EU directive is potentially very important, but I think there are a number of weaknesses in the draft at the moment. I hope it can be strengthened, including in relation to its scope, and the requirements, particularly around consultation and engagement with affected communities, with trade unions, with workers, and the reporting requirements. So yes, potentially a very useful tool in terms of combating trafficking for forced labor, which is sometimes also combined with other purposes of exploitation. But we need to see those tools being strengthened and used more effectively. Thanks.
Perhaps Martina would like to also respond to this, and also just to note that there was a related question from Favor, who spoke about the finances of trafficking and the strong relationship between finance, big business, corporations, and government policies, and whether the research touched on that. So in responding, please feel free to broaden your response to cover both. Thanks, Martina. Thanks, Favor.
I'll be very, very brief and just utter two words: import bans. Because I do feel like this trade remedy is one of the most powerful things that has made businesses, has forced them to actually do the mandatory due diligence, the now voluntary due diligence, to even examine their supply chains beyond tier 1 or tier 2. And we are working with a global coalition of non-governmental organizations to build what we call no safe harbor for forced labor, because we want to see import bans in every economy across the globe, so that literally containers cannot just be turned around from a port in the United States and shipped to Mexico or shipped to some other destination, but there's literally no safe harbor. The other answer I'll give very briefly on the financing piece is it is time for the banks to start thinking about what they are financing. And one of the remarkable activities that happened here in the United States was a series of lawsuits against the private prison companies alleging that they were engaging in forced labor against immigrant detainees There's a lawyer, Andrew Free, who spearheaded a lot of that strategic litigation, but it wasn't just the litigation. They also went to shareholders and they also went to banks and asked why those organizations were continuing to finance private prisons in the United States that had allegedly engaged in this activity. So I think as advocates, we have to be a lot more sophisticated and use multi-pronged activities, not just in the courthouses, but also at the SEC and also with shareholders and also with banks.
If I could just add one quick thing to that, I think one of the things that the research does find is that there is that connection between industries and big business that are involved in the country that are particularly important for a particular country's economy, for example, big employers, etc., and the reluctance of states to go after those companies or exploitation in those sectors. 100% agreed with both Siobhan and Martina on the need to use the business and human rights tools that we currently have or that are being developed in many countries, and hopefully eventually the EU directive comes into play. And the other thing, and this kind of strikes me from something Martina was just saying, is the need for when we talk about training of the anti-trafficking movement and building the capacity of civil society organizations, of the anti-trafficking civil society organizations, is also training civil society organizations to engage with those processes that might fall outside the kind of what we immediately think of as anti-trafficking efforts, thinking about how we engage with shareholders, how we engage with the SEC in the US context, et cetera, et cetera. So I think that is something that could indirectly also affect if we have more civil society organizations engaging with that. And that kind of made me think of Professor Malali's kind of a report this year on climate change, and the fact that obviously while there's a lot of connections between climate change and trafficking and vulnerability to trafficking, we can also learn lessons from the anti-trafficking movement for the anti-climate change movement, but also from the kind of climate action that is that's happening and the actions against financial institutions in that context and how that can be used in the context of anti-trafficking as well. So I think that kind of cross-fertilization of good approaches, of positive approaches, of approaches that lead to positive results can be beneficial for both sides of that equation, or the multiple sides of that equation. It's not just two.
Thanks, Jean-Pierre. Couple more questions I think we have time for. Oh, sorry, please, Professor Malali.
Sorry, yeah, just very quickly, I was going to say, I've just published a report, my mandate report to the Human Rights Council, which looks at trafficking in persons in the agriculture sector and human rights due diligence. So it has some comments on the EU directive and more broadly on that topic. I can put the link here in case it's of interest. Thanks.
Please do put that in the chat. Catherine Baldacchino, again, who likes to ask million-dollar questions, she asks, given how entrenched the counter-trafficking framing is, based so heavily on prosecution and discriminating against migrants, how can we turn it around? Has the ship sailed, or can we fix this? Please, in 2 minutes, please answer that question.
I think we've had a couple of suggestions of how to do that. I think one was, well, not creative, but kind of forward-looking interpretation of the current instruments that start changing the framing. And the second is Martina's point on the role of survivor organizations, survivor-led organizations, and starting to change the narrative away from prosecution and towards protection, prevention, et cetera, et cetera. So I think those are at least two ways in which we can start changing that understanding. And I think there's another benefit to starting to make that change, which is that the more we focus on prosecution, the more we're focusing on the individual trafficker as causing trafficking, as being the main problem behind trafficking. And that lets states get away with the policies, with the kind of practices that they have that increase vulnerability to trafficking, that cause trafficking in some cases, et cetera, which is something else that we try to deal with in the report. And that's something that I'm sure that would require a lot more thinking, I think, moving forward.
Martina?
I think Martina has her hand up.
Yeah, I would say we are already turning the QE2. It is already turning. And I would echo what Jean-Pierre has said about the survivors are turning the ship. But the other thing that we are seeing, and again, my context is largely the US context. And here, the National Plan of Action released by the Biden administration says explicitly that they plan to target corporations in their prosecutorial strategy. And it is indeed already happening. So there's an indictment, Operation Blooming Onion. I don't name these things, but yeah, that's what they called it, Operation Blooming Onion. And it's an indictment of more than 20 defendants with allegations of involvement by Department of Labor officials in the state of Georgia. So it's a case that involves allegations of corruption. And they've indicted this case, and the allegations in the indictment, Operation Blooming Onion, are that more than 80,000 false visa applications went in for agricultural workers, and that the perpetrators, who were recruiters and corporate actors, that they laundered more than $200 million through US casinos. So I think I really see that particular indictment as a sign, I hope, of things to come. But I do think we can turn the ship. I think it's turning, it's just turning slowly.
I like winding things up on an optimistic note, Martina. So thank you very much for that. I always find it striking that the world is so very comfortable talking about 40 million modern slaves in the world, but what is the figure of how many traffickers are putting them in that situation? You know, when are we going to start actually asking, who are these slave drivers? Who are these traffickers? Are we actually going to start naming corporations and indeed states who are involved? And perhaps we're getting closer to that. We could talk for the rest of the evening, but we can't do that. So to see us out, I think before we close, I'd like to offer participants a final opportunity to just give a very brief minute of reflection to say what you didn't get to say before. So perhaps first, Professor Mullally, if I can invite you, any final thoughts?
No, just to say, I think the report gives us a lot of very useful, concrete evidence that can hopefully inform how we think about anti-trafficking action in the future, and really think about the importance of the specifics of context and engaging with communities directly affected. And again, to reiterate what Martina has said, I think survivor leadership on these points is going to be critical in the future and can really inform and build on the kind of work that's been done here, this important research that gives us a really in-depth analysis of what to focus on in terms of shaping the most effective anti-trafficking action. So thank you.
Hear, hear. Martina?
Just, I want to close out with, again, congratulations to the authors and the researchers of the report. And again, to point to this question of where are we driving? And then as Professor Mullally said, who's in the driver's seat? Where are we going, and who's leading?
Thank you. Noemi?
Let's try this again. I would really like to, besides apologizing for my internet issue, thank you all for having provided your opinion, feedback, questions on the report, which we really will be disseminating as much as possible, and hope that the entire variety of the stakeholders that we talk about in the report will be able to take this, mix it with the context, and actually start the mapping exercise within context that we might not have looked at, to do the same sort of thinking around how determinants interact, what is a determinant and what is not. And in particular, I think that the way in which we highlighted negative determinants, those might be turned. So instead of only looking at what worked, we make it work. I think it's moving forward. Thank you.
Thank you, Noemi. And finally, Jean-Pierre.
Thank you very much, Marika, and thanks everyone. I think I'll just use a couple of minutes to say a number of words of thanks for the projects more broadly. So let me just start with the event today. I did want to say a massive thank you to you, Marika, to Martina, to Siobhan for being here and for your extremely useful insights that you have shared with us today, as well as throughout kind of the project as interviewees, as expert panel members, etc. So I'm eternally grateful for that. The second group I want to thank is the Office to Monitor and Combat Trafficking in Persons at the US State Department and the US government more generally for generously funding the project. We would not have been in a position to do this project if it wasn't for the generous support, and we really very much appreciate it. And in particular there, Janet Zinn, who is the program officer responsible for our project from the JTIP office side, and who's been incredibly supportive and enthusiastic about this project throughout the 2.5 years. Next category is my colleagues at BIICL, and I would not have been anywhere close to able to do this project if it wasn't for 3 people in particular, 2 of 4 on your screen right now. So Noemi Maguliani and Iris Anastasiadou, as well as Victoria Wyndham, who is not on screen but is participating in the event today. Noemi was the research fellow on the project, Iris the research assistant, and Victoria the project manager. It's been an absolute pleasure working with the 3 of you over the past 2.5 years on this project and moving it forward. And I also did want to thank Adele Henley and Denny Duncan, who are also involved in the project at different points throughout the project. Other BIICL colleagues who are also involved in informal conversations, informal support for the project, and informal conversations around kind of some of the topics and how they engage, and that helped us think through some of these issues. The national research consultants, we had 14 country reports, all developed by country experts, and we wanted that local knowledge, we wanted that local expertise to shine through those reports. Those reports will also be made public with the final report, but we are eternally grateful for those research consultants who helped us through that country research level. Besides the country researchers, also the interviewees in the 54 plus interviews that we carried out in the context of the project, the respondents to the survey, the people who emailed us to say, oh, this is what I think about these topics, all of those participants in the project more broadly and the anti-trafficking movement more generally, we are very, very grateful. The expert panel, of which Marika is a member, but we also had another 10 members of that expert panel, again, for your input, both in terms of the design of the research tools, but also of the report and the thinking around a lot of these issues. And with that, and again, for the event today, returning to the event today, I also want to thank the events team at BIICL, Liam, who is behind the BIICL logo, as well as Bradley and Carmel in the BIICL events team. This event would not have happened if it wasn't for them. So thank you so much to everyone, and I'll stop there.
Thank you so much, Jean-Pierre. That brings us to a perfect end. I think the only thank you left to be made, in addition to all of those, and I congratulate everyone that you mentioned then, it's really fine work. But from all of us on screen, thank you to all of you who have tuned in. We really appreciate your interest and the time you took from something else to be here with us. We are really grateful for that. And we hope that you will use these findings far and wide. So on that note, thank you all so much again, and farewell.